All right, good afternoon, everyone. I want to welcome you all to the Yearlings and University of Louisville and the Yearlings Forum on Justice for All in All Courts. We have a distinguished panel, and we thank you for taking the time out of your day just to join in with us. And we really appreciate that. It means a lot to the University of Louisville and to the Yearlings Club that you guys participate in these forums. So I'd like to introduce you to Dr. Sherry Dawson Edwards. She is Associate Dean with the Arts and Science Equity Inclusion Program. She's Associate Professor and also with the Criminal Justice, she's the Criminal Justice Director of Social Change. With no further ado, I'd like to introduce you to Dr. Sherry Edwards Dawson. Thank you.
Thank you very much. I really appreciate the Yearlings Club for always supporting and sponsoring this forum series. I think it's very important for not just our community. As we've known since COVID, we have been virtual. And so our forum series has become national, if not international. We have a lot of guests that pick up on our series through social media and things like that. So I welcome folks that are not in Louisville to a form of some of Louisville's greatest. I'm very pleased with the panel and everyone agreeing to take their time out for such an important topic. Last month's topic was about race and police. We felt like it was important for us to continue on a trajectory of public conversation and education around the criminal justice system. I often, and Professor Gutman can probably chime in on this, but in a curriculum, a criminal justice curriculum such as ours at the University of Louisville, we have law classes, we have intro to criminal justice, we have policing classes, but we don't do the best job of spending a lot of time on the courts. It's almost like it's the black box. So like what happens before and then courts and then, oh, what happens after? So I think it's very important for public conversations to include conversations about all the different things related to racial and ethnic disparities in the court aspect of our system. So I'll just do a little introduction and then I'll read the bios to our esteemed panelists, and then we'll get started with the conversation. In an article appearing in the Marshall Project called "A Growing Number of State Courts Are Confronting Unconscious Racism in Jury Selection," written by Beth Swartzelfeppel, I should have practiced that. The author points out that recent research has unveiled unconscious racism driving everything from police-involved shootings of Black men to charging decisions made by prosecutors. Researchers have found that people are more likely to perceive Black people as guilty, more likely to shoot them in police simulations, and more likely to remove them from juries, even when their other demographics are identical to white potential jurors. At the core of recent arguments about racism in jury selection is the recognition that attorneys too often rely on stereotypes, like who is going to be sympathetic or not, says Catherine Grasso, a Michigan State University law professor who co-authored a seminal 2012 study of death penalty cases in North Carolina. The study found that Black people were removed from juries at more than twice the rate of those of other races. Our panel today will discuss the issues around racism in the court system. Based on their current work to address, and historical work, I would say, to address inequities in the court system, our panelists will share their perspectives on Kentucky's efforts to address injustices in the courts. We are extremely pleased to welcome our panel who will discuss their work and experiences with the courts. We hope you will enjoy this very engaging discussion, and please join me in welcoming our esteemed panelists. So our first panelist is the Honorable Denise Clayton, who is Chief Judge of the Kentucky Court of Appeals. Judge Clayton was elected on June 1st, 2018 by her fellow Court of Appeals judges. Judge Clayton became the first Black woman to serve on the Kentucky Court of Appeals in October 2007, where she serves the 4th Appellate District, Division 2. Most recently, Judge Clayton was appointed as the chairwoman for the Chief Justice's Commission on Racial Fairness for Jefferson County's courts. Prior to her appointment and election to the Court of Appeals, Judge Clayton was Chief Circuit Judge for Jefferson County Circuit Courts and was the first Black woman to be a Kentucky Circuit Court judge. Judge Clayton previously served in Jefferson County as a judge for District Court, Family Court, and Drug Court. Judge Clayton's legal career has included attorney with the Internal Revenue Service, University of Louisville Student Legal Services, Associate Director of the Legal Aid Society. Judge Clayton graduated cum laude with a bachelor's degree from Defiance College in Defiance, Ohio. She earned her Juris Doctorate degree from the University of Louisville's Brandeis School of Law. Thank you, Judge Clayton. Our next panelist is Aubrey Williams, attorney at Aubrey Williams and Associates. With over 30 years as a trial lawyer with a focus in criminal law, Aubrey Williams has a distinguished career as a criminal defense attorney specializing in criminal defense, personal injury, civil rights, environmental law, domestic, probate, business, and family law. Mr. Williams represented Louisville's 41st Legislative District in the Kentucky House of Representatives for 3.5 terms. He was appointed by former Governor Julian Carroll to a judicial seat on the Jefferson County Magistrate Court, the predecessor of today's civil court. A dedicated community leader, minister, and who puts his family first, he has served as the president of the National Bar Association and the Louisville chapter of the NAACP. Mr. Williams received his Juris Doctorate from the Brandeis School of Law at the University of Louisville and BS from Pikeville College in Kentucky. Tara Bo Blair is the executive officer for the Kentucky Court of Justice Administrative Office of the Court's Department of Pretrial Services. Tara joined the department in 1995 and has extensive experience in developing the program's mission, goals, and objectives, pretrial risk assessment, and data management. She authored policies and procedures and developed the training module for new and existing staff, as well as interdisciplinary training with the Department of Public Advocacy, state prosecutors, and the circuit and district judicial colleges. She led the design and implementation of the pretrial case management system, pretrial release information management, or PRIM. Mrs. Blair holds a BA in sociology and a BS in police administration from Eastern Kentucky University. Our next panelist, Joe Gutman, is an attorney, former prosecutor, and current U of L faculty member who leads the Central High School Law Magnet Program. Joe Gutman began his career in law in 1981 and joined the Office of the Commonwealth Attorney in November of 1982, where he served as an assistant Commonwealth attorney. Gutman received his BA from the University of Louisville and his Juris Doctorate from Northern Kentucky University Salmon B. Chase College of Law. During his 20-year tenure at the Commonwealth Attorney's Office, he handled more than 2,500 felony cases and was the division chief of the Major Offense Bureau, the Fatal Accident Support Team, and the Career Criminal Bureau. He has been an adjunct faculty member at the University of Louisville since 1984, teaching in the Paralegal Studies Department in Political Science and Criminal Justice. Following 9/11, the then successful prosecutor decided to make a difference in a new way. He left the prosecutor's office to teach at Central High School. In 2005, he was asked to serve as the coordinator of Central's Law and Government Magnet Program, and he began using the street law materials for the sophomore magnet students. Building on the partnership begun in 2001 between Central and the Brandeis School of Law, law students were approved to receive public service credit for their street law work. A recipient of numerous awards, Mr. Gutman was named Educator of the Year by Street Law, as noted in one nomination letter. He is a tireless advocate for his students, the letter concluded. The Central students who are in his class and the law students who teach in the Law Magnet think highly of Joe. The admiration and affection and respect students have for Joe doesn't stop when they graduate. And our final panelist is Shamika Parrish-Wright, who is the operations manager at the Bail Project. Prior to joining the Bail Project, Shamika worked as a community and voter empowerment organizer, a project manager, and most recently as a campaign manager. As a child of an incarcerated parent and formerly incarcerated person herself, Shamika spends weekends doing art activities with families during visitation with a special project, a project of the Kentucky Foundation for Women. She serves on the board of the Ann Braden Institute for Social Justice Research, Community Council, and the Sowers of Justice Network, among others. She holds a degree in human resources and currently lives in Louisville with her partner and 6 children. So again, thank you to all of the panelists. You all have wonderful bios, and we are privileged to be here to have a conversation with you today. I think I'm going to start with Judge Denise Clayton, if you all don't mind. Judge, in 2001, the Chief Justice's Racial Fairness Commission was formed in Jefferson County to address complaints of unfairness from Louisville's African-American community in matters of jury selection, setting of bail, and sentencing and probation. The commission, initially chaired by the late Justice William McEnulty, has been led by you of the Kentucky Court of Appeals since 2005. Can you please discuss the results of surveys conducted by the commission and the efforts to ensure fairness in the court system, and maybe, you know, provide some context to the world and space that we're living in today and why that information from the commission is still so relevant and important for us.
Well, thank you. And I appreciate being offered the opportunity to participate on the panel and with my esteemed colleagues on the panel. Thank you for the introduction. You did, it was failed to mention that I did graduate from Central High School, so we should throw that out there. As you said, the Chief Justice of the Supreme Court at that time, Joseph Lambert, formed this commission that is comprised of judges, prosecutors, defense counsel, community activists, and court personnel to look at 4 particular areas of our court system. And we have looked at sentencing, bail, jury selection, and courtroom environment. Courtroom environment really pertains to the perceptions that people have about the justice system. So we have issued reports in each of those areas, and we have issued recommendations in each of those areas. We have done surveys, multiple surveys over the years. In one area, courtroom environment, we've done it twice. We just did a community-wide survey about a year ago, which was on several different platforms, as well as hard copies to ascertain people's perceptions of the court system. We have done surveys of juries to determine racial diversity. So our work is ongoing. And I would say, in addition to the reports of the Racial Fairness Commission, you should also be aware that last year, again, with the survey, we had a listening session, which was community-wide, followed up by focus groups. We had also and I know Ms. Blair can talk about this, the 3-day count program, which has to do with the fact that individuals who stay incarcerated for 3 days can have their lives changed drastically. So some consideration by the courts and judges regarding setting a bail is imperative. I also will note that it was a Racial Fairness Commission that actually brought the National Bail Project to Louisville to introduce what we were doing here to that project. And I'm happy that they have chosen Jefferson County for one of their projects. We also now within the court system have what's called a guide for reducing racial and ethnic disparities, looking at the way in which we do business as a court, which adversely impacts people of color. So the court system has been pretty busy examining its flaws, what we've done wrong, what we are trying to do better. Our report on jury selection, since you mentioned that, was actually done in 2007. We had a whole series of recommendations. A lot of those recommendations, though, require legislative action. And so we just this year actually were able to get one of our recommendations in place, and that had to do with adding the state issued ID to one of the sources for the master jury list. So we have done a lot of work in this area, and I know there was concern some time ago, a couple of years ago here with jury selection, but the 2007 jury selection report actually identified all those areas of concern with the lack of diversity on juries. Those reports are there, they're public, people can take a look at them. I won't go into detail about them because I don't, obviously other individuals might want to share their views about that. But I will say that the Court of Justice is interested in doing things that they can change. That all aspects of the justice system we can change. We can only change what we're doing. We also like to mention on the jury issue, though, that about 98% of our criminal cases are plea bargained. So although we may be looking at the issue of jury diversity, there may be also another issue we really should be looking at as to the number of cases plea bargained and whether or not people are agreeing to resolve those cases based upon their assessment of the evidence, or are they resolving them because they can't get out of jail without reaching an agreement? That's a big difference. So there are many aspects of the court system that we really need to look at them, but there's all interplay with other partners in our system, including obviously the prosecutor's office. So our listening session last year actually involved the prosecutor's office, both county attorney and Commonwealth attorney, as well as public defender and legal aid, pretrial, probation and parole, and a lot of different players, because it really would take all of us working together for us to really effectuate some significant change.
Thank you. And thank you so much for that overview of all of the different or the varying topics that this issue can address. So I think, because I think kind of linear, even though I know the justice system or process is not necessarily linear, I think it might be a good idea for us to pivot over to Tara, because I know that, you know, Tara, you're going to present some of the data, and I've had the privilege of being on a panel with Tara before, and I was like, ooh, should be great to like show the data, and then we'll move to Shamika, and then probably we'll go to Mr. Williams and then Joe, and kind of work in that, and then come back all together if that sounds okay with everybody. So Tara, the state of Kentucky has received national recognition for its pretrial services. Pretrial services operates under the premise that defendants are presumed innocent until proven guilty and are entitled to reasonable bail. Can you please provide us with an overview of your work, the work your agency does to address the number of folks held and to address the racial disparities of those that are in pretrial services?
Yes, thank you. And I'm glad to go after Judge Clayton, because she said a lot of remarkable things. And the one thing that she said was that, you know, in the courts, you know, we work to change for the better, and we can only work on the things that we can change. That's sort of, actually, that is what we've been doing in pretrial services for over 45 years. Pretrial was created in 1976 when commercial bail bondsmen were outlawed here in Kentucky. Some of the attorneys on here, I think, remember the bail bonding days. I, of course, was a child then. So, but anyway, that's why we were created, was to fix a broken system at the time. So what pretrial, and I'll do a quick overview, like literally like a less than minute overview so I can get to the data, but pretrial officers work 24/7. We interview all defendants that are arrested. We perform a risk assessment, and then we decide based on the risk assessment and the charge if they're eligible for administrative release, and that is release from a pretrial officer without contacting a judge. If a defendant is not eligible for that release, then we present to a judge within 12 hours of arrest. Therefore, that's why we have to work 24 hours a day, 7 days a week. The judge then can make the decision whether to release the defendant on a recognizance release, an unsecured bond, either one with conditions, or they can set a money financial amount that the defendant would have to pay. So defendants that are released, whether or not they have conditions, then they are to return back to court on their own. If they have a money bond that cannot be paid, then of course they're held in jail until they actually see a judge at arraignment. So that's sort of like the really quick down and dirty. The risk assessment piece, and I want to also play off of what Judge Clayton said about the racial fairness piece. Back in, and I believe it was 2003, it may have been somewhere around there, but one of the recommendations from that group was that pretrial services look at our risk assessment, because on its face, it appeared that it had some racial bias to it in the sort of questions that we asked and the way that defendants were scored. So we did look at that based on those recommendations, and we did find that there were disparities and biases within our risk assessment. So we changed it. We changed it actually in 2006, again in 2010, and again in 2013. So some of the data that I'm going to provide for you today is looking at that risk assessment and how defendants score. And we have that separated between Black and white defendants to see if the disparities and disproportionality still exist. So I'm going to go ahead and share my screen, and I'm going to give you, first I'm going to give you an idea of how the risk assessment works. Well, not really works, but how people are classified by score and what the release outcomes are for those. Okay. Okay, so I hope that everyone can see my screen up here. Basically, we have two scales. We have a criminal activity scale and a failure to appear scale. This here is the new criminal activity scale that's over here. So the scale goes from 0 up to 10, 0 meaning the least risk for new criminal activity, 10 plus being the most risk for criminal activity. So if you can see, 92% of individuals that scored a 0 were actually released from jail, and 95% did not commit any crime while they were out awaiting trial. We only look at crime committed during the pretrial phase, because once one is convicted, of course, or not convicted when their case is disposed of, then they move on. They're not to probation, or they're not part of pretrial. So it's just that window of time between release and disposition of case. So as you can see, the higher the score, the lower the safety rate. So people that scored a 10 plus, only 63% did not commit a new crime pending trial, versus the ones that scored 0, 95. This was, I looked at calendar year 2017 and 19, and then I separated out 2020 just because of COVID. A lot of things changed with our release protocols and who was eligible for release. So our release rate is a lot higher in this year than it was in 17 and 19. Then on to the appearance rate. Again, those that scored a 0, 90% made all court appearances, versus those that scored a 7 was 55%. So that's just an overview of kind of like how the scoring is and what the actual outcomes are. But I want you all to see when we bring in race and see how that changes. So I think this is really important here. First and foremost, our administrative release is what I was talking about, that delegated release where a defendant can be released by pretrial without going to a judge. There were some changes due to the COVID pandemic, to where the Supreme Court increased the different circumstances where someone could be released. So if you look at this April to May, and of course blue is 18, red is 19, and green is 2020, you can see that we went from releasing 10% of arrests up to 39. That was where we were releasing everyone charged with a bench warrant that did not score high risk for NCA. We were releasing civil cases. We were releasing felonies. There was a lot of inclusions there. On June the 1st, it changed. And basically we were releasing everyone except for people that were charged with a bench warrant for failure to appear. And let me back up. I'm going a little bit too fast. 10 minutes is a lot for me to get all this out. The only people that we can release are people that are charged with a non-violent, non-sexual misdemeanor or Class D felony. So if you're charged with a violent or a sexual offense, you're not eligible for administrative release. So these are your low-level crimes, low risk. That was 29%. And the order that we're operating under today is they changed it again and made a couple of tweaks, and it was for the better, because what was happening is people were being arrested and then released, and then getting arrested again and released again and arrested again and released again. So anyone that had a pending case that was currently on pretrial release was not eligible for this quick expedited administrative release. So even today, we're releasing 20% of the arrest on that program. So let's look at race. What I did here is the statewide numbers do not give you a true picture. When you're looking at race and ethnicity, if you look at statewide, it does not even begin to show where the disproportionalities is. So I like to focus on the counties where we actually are seeing people that are not white get arrested, because in a lot of the rural counties, everybody looks like me. So I pulled out Jefferson, Fayette, Christian, and Hardin counties. So this first line over here is where Black defendants, white defendants. This first blue line is the total number of arrests. Now, these are not unique individuals, because one person could be arrested multiple times throughout this, and this is a 2.5-year period. So these are arrests. 42% of arrests for this period were Black defendants versus 58% of white. Now, there is no county in the state that has a population that's 42% Black and 58% white. So it's very obvious that there's disproportionality at this arrest stage on who is coming through the jail. It is not proportionate with the population at all, and Black defendants are overrepresented in our arrest numbers. If you look at by risk score, the low risk 45% versus 47%. So again, they're slightly disproportionate or disproportionately underproportionated in low. But if you look at high, 11% of Black defendants score high versus 10.4 white. Now that's obviously shows that there is some potential disparity there in those that score high. However, some good news is that when you look at the release rate, 60% of Black defendants were released pre-trial versus 51 or 52% of white defendants. So even though there is a disproportionate number when it comes to the high scoring, and I don't want to make assumptions here because again, these are just raw numbers. This is not like major research. I mean, it hasn't been peer reviewed or anything like this is just data. But it does appear in the data that judges are sort of neutralizing that disproportionality at the release stage, because overall you had a 5% more Black defendants than white defendants were released. Whoops, sorry about that. Now, there is something that we're looking at even further is those that don't get out. What is the length of stay? Because what we're seeing is our jail is still disproportionate. Most of our jail, especially Jefferson, Fayette, and Christian, it doesn't make sense. If Black defendants are released more frequently than white defendants, why is half the population of that jail Black? That's what I'm trying to look into next. That'll be like the next series to see if maybe the case processing and the length of time is longer for Black defendants or if they're charged differently. I mean, these are other things that we need to look at. But again, like Judge Clayton said, we're going to dig down into this. And if there's anything that we can change as the court system and as a pretrial services department to make this better, we're going to change it. And then again, really quick, the FTA scale is a little bit different than the NCA scale and that doesn't have as much criminal history on it. So on this particular scale, actually Black defendants are 10% and white is 10.67 high risk. And then, but again, the release rate is higher. So what we're seeing in the disproportionality is in that NCA scale. And I would assume, and my hunch is that that's the criminal history that's driving that. But then once again, our courts, when they intervene, the release rate is actually higher. So again, I just want to add that in there because there's still so much work to be done in this area. And then lastly, the last slide here, what does it look like in our administrative release, white versus Black? And you'll see that it's very similar. The Black defendants were 12.98 and 13.19, so pretty much 13%. So it doesn't appear that Black defendants are released on administrative release less so than white defendants. So that's kind of a good thing too. But there's so much more work to do in this area. A lot of more work to do in this area, but we're going to continue to look at and stop share. We're going to continue to look at these issues, and I really want to dig down into looking at that jail population and seeing what we can do there to improve on that as well.
Thank you, Tara. And Shamika, is it okay if we shift over to you? I know you are doing double duty. And I understand that is the world we're living in. So I appreciate your time. So here's my question for you. American taxpayers spend more than $14 billion annually incarcerating people who haven't been convicted of any crime, according to the Bell Project, a nonprofit dedicated to decreasing the length of pretrial detention for low-income individuals. Ms. Parrish-Wright, please describe the Bell Project's work and success. Please describe the process used to determine eligibility and any reform recommendations that you all are pushing or are trying to address.
Thank you for this opportunity. I am honored to be here, and I consider you all colleagues, and we've had to cross paths a lot, and we will continue to do that. I'm actually sitting outside of Shoe Carnival, so that's why I'm the weird one, not on video. So I'm going to go off video and use my notes to talk to you all, okay? All right. All right, so the Bell Project, we, as Judge Clayton has alluded to, thanks to the help of the coalition partners and everyone working together, knowing that there was a great need for our services here, a group of folks, including the commission, worked together to bring the Bell Project here to Louisville in May of 2018. Since May, so the work for the Bell Project built off of the Bronze Freedom Fund, which had done 10 years of research and work around what does it take to level the playing field? What does it take to, as we deal with the baked-in injustices in our criminal justice system, what is the best way we can assist folks? And just as Judge Clayton spoke about, we know that the longer you sit in jail pre-trial, the more likelihood that your life falls apart. So by the time someone reaches 3 days, they literally could have lost their home, their children, their job, and just their overall good standing status in the community. And so we know that we want better outcomes. Everyone wants their day in court. And people who have been charged with offenses want to be heard. They want to give their response. And so what we need is people who are able to be the best thing they can be for themselves, which is defend themselves and get the evidence or get the proof needed to show why they should be, they should be treated fairly in the judicial process. So we have, since May of 2018, invested nearly $8 million into getting Louisvillians out. We've bailed out most people in Jefferson County, but we've also bailed out people in the surrounding 10 counties, and as well as Covington, Hardin, a lot of other counties. And so we understand that this need is so great. There's a lot of places where our data matches what Tara says, but I want to be clear about data should never take away from an individual experience or someone's story, because we know that the data says one thing, but the reality that people are living to make these decisions, to take plea deals, to plead out to things that they didn't feel like they did, to not have a fighting chance in our judicial process is way more important than what our numbers say. The numbers are tools for us to use, but like any tool, it can be used to build something and it can be used to destroy something. So I want to be clear as we talk about that. We want to work ourselves out of a job. About a lot of us are directly impacted by the criminal justice system. I always tell people I'm impacted by every way. I'm literally fighting bogus protest charges, so I have to go to court Monday. And I appreciated getting a text today telling me where my courtroom was, telling me that I had a court case tomorrow, reminding me. We've seen a lot of improvements in the judicial system since we've been doing this work. So I don't always want to come from this from a lens of like, we got so much work to do, because we actually do. But I do want to recognize that from corrections to the records, to the administrative office of the clerks, to the prosecutors, we all have been making changes and making the system better and helping people navigate in a better way. Is it perfect? No. Do we still got a lot of work to do, as everyone alluded to? Yes, we got a lot of work to do. What I like to focus on is that we have more clients and with cases and better outcomes. We have less people going to prison. The longer someone sits in jail pre-trial, the more likely they are on this train, is what I call it, a train headed towards mass incarceration. And we all know that Kentucky has the worst incarceration rates when it comes to Black people, when it comes to poor white people, when it comes to children who have parents that are incarcerated, when it comes to women. And so all of us have to do our part. We have work to do. And everyone agrees that our court system can be improved. We have to be better we have to have a better return rate. We, in our work, and we've seen this, where folks who do not have any skin in the game, meaning they didn't pay to get themselves out of jail, their family didn't pay, we paid their bail, we addressed what their needs was if we could, we met them where they were, and they returned to court. We have a better return rate than the court system itself. When I last was on a panel with Commonwealth Attorney Tom Wine, he said the court system's return rate was hovering in the 70s. We have more than 92% return rate. We want to get that to 96%. That is our national average. And so we're pushing right now because of COVID, because thousands of cases have been rescheduled. people don't have the technology to attend Zoom court. I know the public defenders, which is our most amazing partners, have worked it out to where clients can come to their office to attend Zoom court. But we know when something comes up in one of the courts, say someone is COVID positive, then those cases are rescheduled. I really think as a part of something that we all can work on together is bench warrants need to be eliminated, and people need to be given a chance to return to court. If you have a court system that's rescheduled over 40,000 court cases, and you have people who are confused about when to go to court, when not to go to court. We're doing the court reminders. There's court text, but there's still so much confusion because of COVID that it's not the same for any of us, and it's not the same for those who are directly impacted by the incarceration system. I will say another thing that we've noticed is that there are more surety bonds. Surety bonds is anybody on this call, if I had a surety bond, can pay $25 filing fee, make sure I get back to court, and then that's it. And if I come back to court, you don't get the $25 back, but that person is fighting their case. They have a better outcome, and it makes things better. More families can now assist their own loved ones to get out of pretrial incarceration. And so the surety bonds, we've seen more of those, which are good. I hope we keep those going up, as well as 10% bonds. I want to work myself out of a job. People keep saying, you don't really believe that. No, I know that that's the nonprofit mecca, this choice that we all want to do, but I really want to do it. I really want to do it in a real way. And starting with pretrial incarceration is the way that we get there. Our work attempts to level the playing field that's been created by the baked-in injustices in the criminal justice system. And so in leveling that playing field, right now, there's not a lot of trust in the judicial system, and we know that, and we're all doing our parts to work on it and to make sure that that gets better. Working on our return rates, we deal with people's needs. So you asked the question about how we make these decisions. It's a case by case situation. When we go in, we work with the corrections, Department of Corrections. We do an interview. Most of our referrals come from the public defenders, but now because a lot of people know about our work, we get them through Facebook, we get them through text, we get them through voicemail, we get referrals through our website. So we usually drive people to our website, and then the public defenders, when there's arraignment court, they give us a list of people that might qualify for our project. We pay bails from $25,000 to $5,000. Is our soft cap. We have paid up to $25,000 in partnership with a family or a church group or someone's working together to try to get their loved one out. But typically our bails are $25 to $5,000. So we literally paid $275 for a father of 3 to get out, and he was in there 3 weeks on a $275 bond. We see that a lot. And I know for some of us, it's just like, people can't people can't get the money to get their loved ones out. But if that's their rent, if that's their food, if that is what they're going to use to take care of their families, they can't afford to have it held up in our judicial process. Most court cases, some are open and shut, but some average court cases that we've seen take 9 months. And now with COVID, that can go well over a year. And so if this is my grandson and I've paid $500 to get him out, I need to get that $500 back as soon as possible so that I can continue on. I'm on a fixed income, but I don't want to see my grandson sitting in jail. And these are the decisions that we see Louisvillians and Kentuckians making every day, but they want to get their loved ones out. And then that's why our work is needed. And now we have 2 bail funds. So we are the bail project, but we also understand that we wouldn't need the 2 bail funds if the need wasn't great. Like Tara talked about, we do see that a white man and a black man can be charged with the same charge, and that black man's bail is higher than the white man's. I don't know if it's from prior convictions. It literally can be from over policing, because once you get pulled over once, you're likely to get pulled over again. We know that the neighborhoods like in the West End, Newburgh, South End, our international immigrant communities are highly over policed, and there's racial profiling, and those things lead to higher incarceration. A lot of people come through the system through traffic stops. And so, yes, you can see our first client, Mr. Gibbs, came through When we got him, he was in there on an $800 bill that he couldn't afford because he's on a fixed income. And when we looked at his history, it was all related to insurance. He thought the insurance was included in his mortgage, but it wasn't. And so he kept getting pulled over because he drove this Maxima car that he loved. And I wanted to tell him to park the car, but he kept driving his car and kept getting pulled over in that same car. He went to all his court dates. He only had missed one when he was babysitting his grandkids, and we saw him in there. Now, Mr. Gibbs, still, after we bailed him out in May, he was our first client. He's been pulled over 4 times since we bailed him out, but he has not been reincarcerated. He's been able to stay out. He completed his case with us, but he still struggles with profiling because he lives in the West End community off of Broadway, and he's often pulled over again and again and again. So, I mean, I will be remiss if I didn't mention racial profiling and over policing in those communities is what get a lot of people locked up over and over again. Pretrial services are great. Pretrial report can be wrong in its ratings. We've bailed out people who the pretrial services rated as would not come back to court, and they came back to court. They made every court date. But we know that this is a case-by-case situation. We know that risk assessments can be wrong. And sometimes some judges don't even look at the risk assessment. They look at if the prosecutor is advocating because a client is connected to something else, or, it's so many variables that you can't just say it's the risk assessment that keeps people in or doesn't let them be administratively released. But we do know that most judges are doing better in bail setting. Some are helping to by doing more surety bonds, by doing lower bails and getting people out. Even with all the protest-related arrests, there's over 800. I would say, and I had the number before, but I know it's in the 90 percentile. Over 95% of the people that were arrested were released on their own recognizance as a protest-related arrest. But of the ones that did get a cash bail, we're paying more $10,000 bills in this last few months than we ever paid since we've been in operation since May of 2018. So that means if they are arrested protesting or rearrested for protesting, then we're seeing more higher bills than we've ever seen before, in the 10,000, 5,000, 10,000, and a lot of them get home incarceration when they're arrested, which adds another barrier because you have to get releases and things like that. So I just wanted to make sure that I mentioned that I do see improvement. We see it in the bail setting from the judges, and we see that some of them are using their discretion in the best way, but we still have a great deal that's using it in a punitive way. Our successful clients have their hierarchy, our needs met. They get treatment, they get food, they get housing, they get jobs and employment. Those needs are the same isms that many of these communities fight that they go home to. So you can do your best, but if they're going back to the same community where the same struggles are rampant, then that increases their likelihood of reincarceration or recidivism. So we are trying to address that. We're not social workers. We're not lawyers. We're meeting them where they are. They help us identify their needs during our interview process. We interview every day over the phone because of COVID. Before COVID, we would go into the jail and interview them, but now we do them over the phone. We do assistance on Rise Back to Court. We got some extra funding to provide. We put some had COVID coming out of the jail, and we put them in hotels because if we just pay their bail and they go home, then they risk getting their whole family infected. So we've been able to successfully put people in the hotels for 2 weeks to give them an opportunity to quarantine and retest. We continue to do that as much as we can, and because we definitely know that we care about our community. We also talk to the families. They have to give us references. We talk to their employers. Some employers call us and say, "Hey, my client, my worker was locked up. Can you help them?" And that is something that we can accelerate, because if they're going to come out and be able to still keep their job, then that makes it better for all of us if they're able to do that. And then I'll end with like I said, there's places where our data is matched with what Tara just gave, but there's also places where we can really, really improve, and that is more surety bonds. I think Chief Justice Minton did an amazing job for the releases of during COVID-19. The same with our governor, Bashir. We need to keep those releases going, even as our COVID numbers decline. I'm hoping they decline soon, but we still need to make sure we keep those releases, because we still see less people recidivating. People do better when they're at home in their communities and fighting their cases. If a family works to get someone out, when they have court, I text them. I said, Johnny has court. They all make sure that Johnny gets to court. We know that people that have community support, that have jobs, they're able to be with their children, or they don't want to mess up and they don't want to be in jail, so they come back to court. We do see aggressiveness in forfeitures. I think if you have over 40,000 cases that are being rescheduled, why is our Commonwealth and our county attorneys, prosecutors being really aggressive with forfeitures? Some of them, we don't even get notices. They just, if a client is late to court, or they got on the wrong Zoom call, or it can be a myriad of reasons, and they're really aggressive at taking our money. The good thing is, and don't share this with them, is that they're not taking a great deal of the money. We are actually in a good place, but with all the rescheduling of COVID cases and court dates, we want to be careful and not let that number get out of whack, because we are a revolving bail fund. So once that money is released from a client, it comes back into our bail fund. And as that money recycles, it can get out up to 3 more people out off of that one bail paid. So we need most of the money to come back in the bail fund. And so it is important that we all be mindful of that, because that's helping people get out. The jail, when the last report I got from the corrections was that it was $83 a day, average stay of 23 days per person that's locked up. Now, if that person has mental health issues, if they have issues around drug and alcohol abuse, that's an additional $300 added to their processing in the jail. So we are literally saving our city millions of dollars. We need everyone to work together, because we are in it to make sure that the better outcomes for those who are victims, as well as those who are processing the judicial process. So the best thing that I can say, leaving this conversation, is that everybody should do their part. We hope that the LMPD, even with the COVID outbreaks, have not stopped going to arrest people on bench warrants. That's missed court cases, whether it's a traffic court case, whether it's a petty theft case, whatever it is, they're still arresting people. The jail numbers are going up, and we're at the point where we might have to reopen community corrections, CCC, because the numbers continue to climb. Every week I get a jail count as what our numbers are, and our numbers are going up at an alarming rate. And I don't have to tell you all that COVID-19 in those jails is a death sentence. If you think that I'm guilty for stealing a can of milk and then I die in jail because of COVID, that is a travesty for our whole community. So we should not be holding people pre-trial on these low-level offenses, and we should be letting people get out. And our jail has to do its part. And I know that they're trying, and I know that all of us are in new territory. We had to reorganize our work. We had to shut down for 2 weeks based on the CDC guidelines, so that I can get it to where my team wouldn't be infecting anyone, and they wouldn't be infected by COVID. So we all have to do our part. But the best thing for the jail is to keep those numbers low, so they can operate safely and they don't have to reopen another jail that was able to close down. So I hope that everyone, I'll be happy to answer any more questions, but I think that's the most important thing. Let's keep those releases going. Let's get people out, and let's help get them back to court so that everyone can have a better outcome.
Thank you, Shamika. And also thank you for bringing in the impact that COVID has had on how the justice system operates, and how we've had to rethink things that I would think for people who are interested in reimagining justice or reforming our justice process would welcome some of the decisions that had to be made because of COVID, and forcing people to think differently about who's released, who isn't released, and how we can move forward, thinking more of a community based model for addressing things like that. So thanks for bringing up that aspect of it. I just want to open it up for any of the other panelists, because I think think we'll pivot from pretrial, because we've kind of been focusing on pretrial and bail, over into disparities as it relates to jury selection, death penalty, things of that nature. Does anyone have any follow-up or anything related to pretrial that you want to say before we move on to jury selection?
Let me just say that to add what Shamika was saying, that the jail population for October 2020 was 44% white, 53% Black, and 3% others. So we still have that disparity there. We also have the fact that even though nationwide jail populations have decreased, they actually have increased in Kentucky, which is obviously very concerning. The other thing, and I think Shamika gave the cost per day of an inmate. Currently, I know last year that cost per day was about $90 a day. So it's really, it's a very costly way for society to operate, to do it this way in terms of the approach with locking up, so many individuals. I'll also just let you know that in the federal system, they're not faring much better. I got some information from them the other week when I was talking to the U.S. Probation and Parole Department. Their numbers also reflecting some racial and minority disproportionality. I won't go through all that, but one other thing I had mentioned earlier about jury trials, last year in Jefferson County, there were a total of 98 jury trials, and I'm sure Mr. Williams and Mr. Gutman would know that these numbers are particularly low, and they were evenly split between civil and criminal cases. So you're talking about all of 2019 having 49 criminal trials. It tells you that something else is going on here, I think reflective of, again, the concern with perhaps individuals deciding to plea bargain, hope based upon their assessment of the evidence. But my concern is it has a lot to do with whether or not they can get out of jail.
Thank you. Mr. Williams, you want to talk to us a little bit about the history of racial disparities in the criminal justice system, from bias in juries to sentencing issues? What are your views on or experiences related to the existence of systemic racism in the judicial system, and what do we do about it? I think you're muted. Let's see if Celeste can unmute you.
There
we go.
All right. As I said, I don't think we have enough time to cover all of this. But at any rate, very quickly, I'm a graduate of Rosenwald High School in Harlan, Kentucky, and I've done a very poor job of my resume. I only attended Pikeville College one semester. I was a basketball player, and I went to college on basketball scholarships, academic scholarships. The other schools I went to were Emory University, Case Western Reserve University in Cleveland, Ohio, Kentucky State University, East Carolina University, and got a PhD and a master's in Christian ethics and philosophy at Southern Baptist Theological Seminary. Now, having said that, my comments I took from, and if you want to, I want to share this book with you. It's called Black Robes, White Justice: Why Our Legal System Doesn't Work for Blacks. It was written by Bruce Wright, the New York Supreme Court Justice, and copyrighted in 1987. And in his book, Justice Wright says that our legal system does not work for Blacks. He states that too many white judges have no understanding of racism or its influence on their thinking and conduct. He goes on to state that a double standard continues to be the rule. And he gives an example in 1989 where a white doctor was convicted of raping a Black patient. He was sentenced to probation. In contrast, a Black doctor who was accused of or convicted of raping white patients was sentenced to 6 consecutive life sentences. Now, we have a problem. He writes that judges come to the bench without any meaningful orientation or examinations, without any testing for intellectual or psychological ability to cope fairly and impartially. As a matter of fact, I attended a seminar in Los Angeles last year and it's an annual seminar put on by the National Association of Criminal Defense Lawyers, and where one judge in Washington, D.C., a federal judge, presents a video to the prospective jury or prospective jurors, helping them and enabling them to recognize their racial unconsciousness. I wrote a piece that I submitted to the Courier Journal back a few months ago at the beginning of, or in the midst of, the Breonna Taylor case that they rejected, which did not really surprise me, because when I was in the legislature, I called them out. They pretend to be liberal and progressive, but they had no Blacks and no women on the editorial staff. And after my criticism of them from the floor, within a week or two, they had a Black on the editorial board, and they had women on the editorial board. So, but anyway, the reality is that the jury system works against Black people. I have a case right now. Let me back up a moment. When I walk into the court system, when I walk into a courtroom, I am not concerned about anything else but whether I am going to be treated fairly because of my race or unfairly because of my race. Now, I represent Black and white clients, and I can say to you that I am more successful with my white clients than I am with my Black clients. Now, I have to jump up and down on the table like my mentor of mine, the great Kenneth Cockrell out of Detroit, said to a group of us when we were in law school, that unless you're willing to jump up on the table like an 800-pound gorilla, you are not going to be an effective lawyer. The National Bar Association was formed to address racial discrimination in the courtroom all over this country. Now, the judges can say they recognize that, and have to agree with me, that many lawyers are intimidated by judges. Now, you have some judges that are absolute, but I'll be careful about what I'll say, because I lost my license for 90 days for calling a judge a racist for something horrible he did. But my 90 days lasted for 5 years. I had to sue the Kentucky Supreme Court and the Kentucky Bar Association before I got my license back. In the judge, they had a hearing on my charge against him. They did not invite me to the hearing. And of course, he was completely exonerated. Now, the problem is, all right, and people are too afraid to speak out about racism. And that's one thing that got me in trouble. And one reason, but Sterling Neal said, when they did that to me, and Matty Jones and Matty Mathis came up to him and said, why don't you guys do more to help us deal with racism in the courts? And Sterling said, if they can do that to Aubrey, who had represented the President of the United States of America, Jimmy Carter, twice, by the way, Now, what chance do any of us have, okay, if we buck the system? Now, so that's my, no, so what can we do? We can, I would suggest that Kentucky or someone here in Kentucky goes to the Supreme Court of Kentucky and recommend to and suggest to the Supreme Court that they have training along those lines about the racial insensitivity or unawareness of their unconscious racism for the bench. Now, we are simply not being honest with ourselves if we think that those judges coming to that court, they who come from backgrounds much different than those of the people who appear before them, particularly in the criminal justice system. See, we are just not being honest with ourselves. So it needs to be addressed. It has not been addressed. Now, during my tenure as president of the National Bar Association, we held forums every election for the judicial candidates, and we rated them. We, as the National Bar Association, were active in the community dealing with suspension of Black students from the schools that were very disproportionate. There were a number of things we did. So the point I want to make there is that while there's a responsibility the part of the judicial system in Kentucky, there's also a responsibility in the Black community on things it should be doing, i.e. the National Bar Association, the NAACP are basically silent. They are not addressing these issues. Now, I make some people squirm when I talk. That's been my history, and I don't make any apology for it. And I have been practicing law now almost 50 years, not 30, all right? And I'm not trying to make friends with anybody. I'm just trying to do my job and get to heaven, all right? Now, we have to be real if we want to address racism in the court system. I tried a case in federal court a few months ago, and I discovered after the trial that a member of the jury who was a relative or whose father or his uncle was an officer in a local police department. He concealed that from the court and from me. And then but I had a juror to come forward. I had to jump through some hoops in order to get the case before the judge because of the strict rules. But this juror, by the way, they thought she was Hispanic. Everybody else was white. They thought she was Hispanic because she was biracial. She looked white. So they felt at liberty to say things about my client, his lady friend, and indeed about me and my mentee and my assistant. They referred to us as the Cosby Show. Now, and when I made a motion for a mistrial, all right, I said to the court, and I put it in writing, I said, now, that juror that concealed that from the court is inexcusable, and I asked for a mistrial. It was declined, okay, rejected, all right. And I said, in effect, when they said what they did about me and my assistants and my mentee, a young lawyer, I said, they were calling us niggers, okay, or jungle bunnies. And then the lawyer for the other side for the, I was suing for police brutality, by the way, all right? He was offended by that, okay? I said, down in Harlan County, where I come from, we believe in putting it down there where the goats can get to it, okay? So that is the attitude in the minds of so many jurors. I had a judge to say, take offense at someone saying that a prospective member of the panel was racist or wanting him to deal with race. And the judge said, I don't believe that, okay? So that's the kind of stuff we bump up against. But when we bump up against that, we better be ready to be willing to take a hit, which is what I did, okay? That's all right. Now, so we have a responsibility on the part of the judicial system itself. We have a responsibility in the Black community itself. Black folk cannot afford to have moribund organizations that are supposed to be and have the moral duty to address racism and discrimination in this court system, right? Rather than handing out awards to white people. And I have nothing against white people now. Most of my best friends are white, okay? Now, but handing awards out to white employers, giving them awards for their work for civil rights, the rights of Black folk, that's absurd. And then we have others standing by the wayside, doing nothing. Okay. Now, say I know. Oh, by the way, I sort of make people feel a little uncomfortable when I speak. Okay. But we need to call it the way it is now. Here's what Justice Wright says. He says, too many white judges have no understanding of racism or its influence on their thinking and conduct. He goes on to state that a double standard continues to be the rule. Then he goes on to say, he writes that judges come to the bench, as I said, without that orientation and that intellectual grasp, if you will, as to their psychological inabilities to cope fairly and impartially. Justice Wright quotes Elmer Berger's Letters of an American Jew that was repeated by Jack Greenberg, who stepped down as the leader of the NAACP Legal Defense Fund, who knows better, he says, who knows better must say so. He deplored the policy of the Anti-Defamation League, that's a Jewish organization, who had been Black folks' friends, but who have become, did become, and remain in certain respects as a more bitter enemy of ours than Anglos. Okay? See, so if we have those former friends who have abandoned us, and then we have Black organizations who are silent and not addressing these issues, what hope do we have? What hope do we have to support just the project that the judge is involved in for a few years? Okay, what hope do we have to advance beyond the oppression that we are suffering from? Right? Oh, and by the way, I was a staff attorney for the Racist and Kentucky Alliance Against Racism and Political Repression. Now, let me give you this anecdote. We had James Taylor, a Black man, handcuffed, mentally ill. He and some buddies of his were getting high up in Smoketown. Two cops come in on them, all right, handcuff James Taylor behind his back, shoots him 13 times in his back and in other parts of his body, all right? The case went to, I spoke to the prosecutor at the time, Dave Stengel, and Harry Rothgerber was his first assistant, and they had the nerve enough to say to me, now here this man is handcuffed behind his back, right? Said it was a good kill. a good kill. I presented the case to, no, they offered him $60,000. His family said to me, should we take it? I said, if you want to, you can. I said, but I'll not be a part of it. I said, we will probably lose, but I would not cheapen. I would not, if I were you, I would not allow them to cheapen my son and my father's death with $60,000. We went to trial. It was an all-white jury except one Asian American, East Indian, who was white, okay? Jury came back, verdict, of course, for the cops and the city. There was one vote for the, to find the officer to deny judgment, and the officer prevails. Now, and guess what? That officer, who was a detective at the time, was promoted from detective to sergeant to captain, okay? And when he retired, he might have been a major, all right? And guess who promoted him? The first and only Black police chief in the history of this community. Folks, now, I know, you know, some of you are probably surprised. It might be a little uncomfortable with the presentation I made here. But until we get the backbone and the courage, all right, to address this oppression that we are still being subjected to, all right, things are not going to get any better. Any questions?
So thank you for that. I just want to go back to one of the points you made about training and judicial training and things of that nature. I know that the Kentucky Court of Justice, at least part of it, I don't know about the whole, you know, thing, has been doing, at least I know Family and Juvenile Justice, Juvenile Services has been undergoing racial equity, not just training, but cultural work in that part of the organization. And I think that that particular work is being expanded beyond just court designated workers in the Family and Juvenile Services Division. So I feel like there's hope that if there's a part of the organization doing that deep dive into racial equity work, which is supported by the upper echelon of the Kentucky Court of Justice, that work will spread, and maybe Judge Clayton or Tara knows more about that, but I do know that that is something that's happening, at least in the administrative office of the courts, that they are doing deep diving for years, like 6 years worth of racial equity work in their organization. So I wanted to just point that out for the public to know.
Well, I will add that, and of course, Mr. Williams is correct in terms of the training the judges need. All the judges now of all court levels have gone through training on implicit bias and cultural competency. That's done at the District Judges College, Circuit Judges, Court of Appeals, and Supreme Court justices have had opportunity to participate in that. It's an ongoing work. You know, you just can't do it once. You have to do it, you have to re-emphasize it. But that work has been started and has been done. The other thing we're looking at is, and we would have hoped we really would have already done this, is not only training for judges in terms of implicit bias, but we were going to produce a video for juries, because we need to make sure jurors are aware of their implicit biases. So that's another project. We have also worked directly with the Jefferson County Public Schools on reducing school-based arrests and suspensions, and that was to begin, but we got, again, derailed a little bit by COVID, but they are on board with doing that, and the county attorney has agreed to divert a lot of those charges to avoid young people from having criminal records. And then the other part of that I would also mention just quickly is I work with restorative justice, which is to allow individuals to avoid criminal records on issues where the victim and the offender can actually get together and come up with a solution that's acceptable to each, restoring the victim to whatever was lost, and also having the offenders to be accountable, but without the creation of a criminal record, because we don't need the creation of any more criminal records. So, and just in response to what Mr. Williams said, I want to just offer that information.
And I'm glad you said that. I had that in my note that we need to show this film. There's the federal judge in DC. All right, he shows a video to the jury pool when they come in. They have to watch this. They have to watch this video. You see, many of these people are not conscious. They are not aware of their racism. Okay. As I said, that was the piece that I wrote to the Courier Journal, which did not publish it, of course, as I said. But we need to quit playing this game, all right? That you walk into that courtroom and the white judge, all right, is looking at the Black defendant and the white victim, right, as equals. They need to be sensitized. We need to address those issues. Things have not changed. I've been practicing law, by the way, not 30-some years, but almost 50 years. Okay?
So if I can interject here really quickly, because I think you actually gave us a good segue to Mr. Gutman, because you said, Mr. Williams, you were like, things have not changed. And I just want to bring him into the conversation to talk about his experiences, particularly in the mid 80s, with a very important case related to the topic that we're talking about today. And so, Mr. Gutman, can you talk a little bit about your experiences, talk about Batson versus Kentucky? I mean, I learned about that as an undergraduate, a graduate student. Like, it's an honor for you to be here today to talk about what it was like, or what you went through with that case back then, and then just how you see how that's playing out in our current, system, and the way that we're talking about inequities and unfairness in the criminal justice system.
Well, thank you, Dr. Dawson, for having me part of this distinguished panel. And Judge Clayton, I would also like to add, not only are you a graduate of Central High School, but you're a member of the Central High School Law and Government Hall of Fame and the Alumni Hall of Fame. And we appreciate all the work that you're doing to make our court system better. Aubrey, it's great to see you after so many years. I'm sorry I'm such a junior attorney. Next year will be my 40th year of practice. But I'm glad to see you still have the fire that I've seen during my entire 40 years of practice. And you are such a great advocate for justice. So it's nice being on a panel with you and seeing you. So I have a PowerPoint that I prepared, but I want to just address everything that's been said as meritorious. And it feeds into what I like to talk to my students about. I argue to them, we have the greatest system of justice in the world, but it's run by human beings, and we have human frailty. And as long as humans are running the system, it's never going to be perfect. Now, you want it to be perfect when it's somebody you love, somebody you care about. Unfortunately, it's not perfect, and it's far from perfect, because humans are running it. So we as humans have to get better to have a better system. And so many of the things that have already been discussed, and this is the good thing, I guess a good thing and a bad thing about being the last panelist, is that many of the things that have been suggested and recommended are great recommendations to make the system better. So can I share my screen at this point? Can you see my screen?
Yes.
Okay. So when I was a first-year law student, there was a popular movie called Injustice for All with Al Pacino. And in that movie, there was all sorts of inequities in our justice system. So the fact that this program is named End Justice for All in the courts, I think is a really good title to discuss some meaningful reform. So I started in the prosecutor's office in November of 1982, and I inherited a group of cases from the prosecutor that left. One of those cases was Commonwealth of Kentucky versus James Kirkland Batson. The case went to trial in March of 1983. So this is in my first few months as an attorney. In that trial, 4 peremptory strikes were used by the prosecutor, me, in striking 4 African-American jurors. Mr. Batson's attorney, Doug Dow at the time, after the jury was selected, and it was an all-white jury, James being an African-American, objected to the jury panel. And as we're walking up to the bench, Judge Ryan, who was the trial judge, former prosecutor, before I opened my mouth, said, Mr. Gutman doesn't have to explain Swain versus Alabama. And that was the end of the discussion at the bench. The Kentucky Supreme Court affirmed Mr. Batson's conviction. He was convicted of 2 felony offenses. And the Kentucky Supreme Court affirmed 4-3. A writ to the Supreme Court was granted. And at the Supreme Court, a 7-2 ruling in favor of Mr. Batson, where the Supreme Court of the United States set a new rule called a Batson issue, and where prosecutors around the country had to give race-neutral explanations for their strikes of jurors. The issues were the 6th and 14th Amendment. And just for the participants in the seminar, that the 6th Amendment gives every citizen the right to a fair trial. It also, under the 14th, every citizen has the right to equal protection and due process of the law. Justice Powell wrote the majority, a 7-2 decision, and he said racial discrimination in the selection of jurors not only deprives the accused of important rights during a trial, but is devastating to the community and the fairness of our system of justice. And so with that, I think Justice Powell and this decision was, number one, it was a landmark decision. It was an important decision because before Batson, under Swain versus Alabama, a defendant had to prove institutional racism. And that was obviously very difficult to prove. So Batson is the case that starts us on an important path towards racial fairness and equity in the jury selection process. As I'm sitting in the Supreme Court, next month will be 35 years ago. As I'm sitting there waiting for the case to be heard, I'm thinking the Supreme Court can only do one of 2 things. They can reaffirm Swain versus Alabama, or they're going to have to address the issue of the real problem in jury selection, and that is peremptory challenges. And I'm going to address that when we've talked about some of the issues that need changing within our court system. That's the number one that I'd like to address for my presentation. So since Batson was decided in 1986, there have been 2 major cases that have reaffirmed Batson. That is Foster v. Chapman in 2016 and Flowers versus Mississippi. In Foster, Justice Roberts said the prosecutor was relentless in trying to keep the jury all white. Flowers, which was decided last year after 6 jury trials, Justice Kavanaugh wrote that there was absolute discrimination by the prosecutor. And in fact, Flowers, who spent 30 years, many of it on death row, is now a free man. So some of the important terms in understanding some of the issues we've discussed today is unanimous verdict, which in criminal trials in Kentucky under the rules of criminal procedure jurors have to reach a unanimous verdict, whether it be for guilt or innocence. So the argument that maybe jury selection is the most important part of a criminal trial is true, because if one juror is on our jury who is biased or prejudiced in any way, there's not going to be a fair trial. And unanimous verdicts require everybody to agree. A strike for cause is when a prospective veneerman informs the court that they have issues either from a past experience or something they've read, heard, something they know about the case that might cause them to be something less than a fair and impartial jury. Sure. And with that, the judge on the motion from one of the parties can strike someone for cause. And that doesn't go against either side in the case. And in any given case, you may have 0 jurors struck for cause, or you can have 10 or 15 struck for cause. So a lot of that discretion falls upon the trial judge. So many of the things that Aubrey says about having judges that are sensitive to this becomes really important in strikes for cause. But I think the single biggest problem with our jury system and why you have racial disparity you have is in peremptory strikes. I talked to defense attorneys and prosecutors, and equally, they both hate my idea. So that supports to me that it's really not such a bad idea, because under criminal rule 9.40, each side in a criminal trial has 8 strikes, peremptory strikes each. And if more than 12 jurors are seated, if 1 or 2 jurors are added, each gets an added strike. So in most trials with an alternate or a couple of alternates, most sides have 9 people they get to throw off the jury for whatever reason. Now, subject to Batson, that it has to be race neutral. Batson has been applied to both civil cases. It is now also extended to gender. But at the same time, why should jurors who meet every other qualification, why should they just be discriminated against by either side? Because peremptory strikes are nothing more than discrimination in its rawest form. So in this, for anybody that wants to learn more about Batson, the Batson case, a few years ago, James and I participated in an NPR show from A More Perfect Union called Object Anyway, that tells a more in-depth story. Here's a picture of James and his mother. And this is our courtroom at Central High School, where Judge Clayton, you've spoken a number of times. And this is James and I.
Batman, it's not changing the slide. I just see
Oh, okay, you're not, okay, it's not scrolling?
Not on my end, no.
Okay. Well, I'll go back to the PowerPoint. It's a picture of James and I in the courtroom discussing how we made legal history. And we'll find a way to make this available. But the podcast is an excellent podcast. You hear from Brian Stevenson and Steve Bright, who have worked on this issue of making our courts, of improvement of our courts. Okay, am I back to, can you see the More Perfect Union or?
Yes, a More
Okay.
Perfect Union Object Anyway.
Yes, can you see the scroll?
No, it's probably a function of Teams when you share on Microsoft. Well, this is Zoom, so I don't know, because sometimes if you click in the wrong box, then it's not sharing your whole screen.
Okay, well, I will go back. Okay. Can you now see John Oliver on juries?
Yes, I can see.
Okay.
That.
Okay. I have put a link to John Oliver. If you've ever watched John Oliver on HBO, he tackles very serious subjects Juries was a subject he tackled about 4 or 5 months ago. It is right on point with many of the items that you've heard today in this discussion. Let me just give you an upfront disclaimer. His language sometime is a little bit on the R-rated side. But at 10:03 in his program, he plays a video clip from a training session from Philadelphia District Attorney Jack McMahon. And it's very disturbing. It is very disturbing. And this is just evidence of how prosecutors are trained in America. This was training video was after Batson was decided. So again, we have issues. Okay, so what I think was really nice about this panel and discussion is everybody made some recommendations without collaborating with each other. And so 35 years post Batson, here were 3 areas that I thought that we could improve in our justice system that will just improve it greatly. Number one, we got to change juror pay. We've got to make it more attractive. To pay a person $12.50 a day, that's disgraceful. We talk about minimum wage being more than that per hour, and our justice system is paying a single mom who's working at for minimum wage. Her replacement salary is going to be $12.50 for the day. That's not an enticement for people to perform their public service. I realize you're performing a really important public service, but we have to increase judicial pay or pay for jurors. I'm a proponent of abolishing peremptory strikes or significantly reduce them. Instead of 9, take them down to 2. So then we're just discriminating a little bit less, but nonetheless, we're still discriminating. I mean, why should there be strikes of potential jurors who qualify in every other sense of the word? It's not right. It feeds into discrimination. And Aubrey's mentioned it. Judge Clayton has mentioned it. Require implicit bias training for prosecutors, judges, and police. And it's got to start with the police, because you've got to remember that it's the police and maybe over-policing that bring all these cases into the justice system where prosecutors and juries have to deal with them. Let me back. And so thank you again for allowing me to participate.
Thank you, Mr. Gutman. And I appreciate your definition slides, because as an educator, I always want to make sure that people that are viewing this kind of know the terminology as well. Oftentimes, those of us who work with or within the criminal justice system, we talk about things, and I know education does the same thing. They have acronyms and terms that we all know that other folks don't know. So I appreciate you adding that slide in. So quickly, I mean, we did have a packed panel this evening, but that hour and a half went by really quickly. There was a question in the chat that Shamika was able to answer about the 2 different bail funds that are local and how sometimes the communication about them get overlapped. So she clarified some information about that in the chat. So we are out of time, but I want to give any one of our panelists a chance to do a last little anything that you want to add. And I guess I'll just call names. And Judge Clayton, do you have any final comments or things that we didn't get to that you think we should know?
Well, first, thank you again for asking me and allowing me to participate. I will just tell Mr. Gutman that in our report on jury selection, our community members totally agreed with you about getting rid of peremptory challenges. But as you said, lawyers for both the defense and prosecution did not want to hear about that. So, but I tend to agree with you in that elimination. It's interesting that Justice Thurgood Marshall said in his concurring opinion in Batson, get rid of the peremptory challenges. So again, that's all I would have to say, and thank you so much.
Thank you. Shamika, do you have anything to say?
Always, but I will keep it short. I learned a great deal about the jury selection process. I finally got selected for jury. I was selected for jury at 21 in Cincinnati, but here I've been here since '02 and just got it. And then it got canceled because of COVID and jury trial cancellation. So I was so happy to be selected. This is so important and such a duty for us as citizens to do our part and do our jobs in the judicial process. So I'm looking forward to helping spread the word, to helping get more people educated. And I just want to thank all of you for giving me the opportunity to join this panel with you.
Thank you, Shamika. Tara, do you have anything?
Just once again, thank you for allowing me to be an opportunity to this. And, you know, I echo what everyone said. We need change. We need systemic change. And it's just such an important topic. And once again, I'm very thankful that I'm able to participate, especially with these lovely people.
I appreciate it. Mr. Williams? Oh, you're muted. Yeah, it's still muted. Joe, do you want to try go?
I want to say thank you. It was a great discussion today, and I hope it leads to meaningful reform.
Mr. Williams, I think you're unmuted now.
Okay, as I said, they who know better must begin to say so, and not be afraid. If somebody's looking down on everything we do, we all have to answer someday. That I say amen.
Well, thank you all again, and thank you to all the participants out there. Sorry that we didn't get to more Q&A, but I think that there was so much information, great information shared about different topics that could have been their own session for sure. But I think we're a lot more educated and informed, at least, about how the courts play into some of the systemic racism and disparities that we see in the criminal justice system. So with that said, I hope everyone has a great evening, and thank you so much for participating on our panel, and thank you for viewing. Good night or good evening.